You may have seen the video I posted last week of police harassing private citizens on their own front porch here in West Virginia. This sort of behavior happens all the time. Cops show up to a private residence, they knock on the door. What are your rights in that situation? What rights do the police have to do what they're doing? Let's make some things clear. Stick with me for just a few minutes and I'll give you the law that you need to know in case you end up with the police at your door. In other words, this is what the police don't want you to know. For instance, in the McDowell County video I just posted, the officer can be heard multiple times in the body cam footage claiming that he had reasonable suspicion to justify his behavior based on the fact that he found what he believed to be 4 marijuana plants near the home. Based on that, the officer demanded the name and birth date of the property owner who was standing on the porch. Can police officers, assuming they have reasonable suspicion to believe that some crime was committed and that the property owner on the front porch may have committed it, can they demand identification under penalty of arrest for obstruction for noncompliance? That's what ended up happening, of course, as you'll see if you watch the footage of what happened to my client Jason Tart. The too long didn't watch answer for this video is no, they can't do that. If police officers are on your private property, that changes things. Cops are trained on the requirement for reasonable suspicion. To develop some reasonable suspicion they can articulate, even if total BS, and then that entitles them, therefore, to forcibly demand identification from whomever they deem a suspect. That's generally how things work in public places, but not on private property, especially a home. Let's look at this scenario of police on your front porch and make sure that we're all on the same page about what the law is and about what the law is not for both police and the occupants of private property. According to the 1980 Supreme Court opinion in Payton versus New York, in order to legally arrest someone in a home rather than in a public place, absent consent or exigent circumstances, police officers must have a warrant. According to the 1984 Supreme Court opinion in Oliver versus United States, the heightened Fourth Amendment protections of the home extend beyond just the interior of the home into what's called the curtilage of the home, which is the land immediately surrounding and associated with the home. Why? Because, according to the Supreme Court, the curtilage is considered part of the home itself for Fourth Amendment protection purposes. The Fourth Circuit, where this porch video occurred, just in 2015 issued an opinion holding that a warrantless search of curtilage is presumed by the courts to be unreasonable. That means illegal. In the 2013 Supreme Court opinion of Florida versus Jardines, the court held that a search undoubtedly occurs when the government, with no warrant, obtains information by physically intruding within the curtilage of a house, which in that actual case involved the home's front porch. The court cautioned that a search occurs unless a homeowner has explicitly or implicitly sanctioned the government's physical intrusion into the constitutionally protected area, i.e. the yard or the front porch of the home. Some of these broad Supreme Court holdings have been interpreted in slightly different ways in different federal appellate circuits. The porch video from last week was from West Virginia, of course, which is in the Fourth Circuit. So the Fourth Circuit made clear as early as 2001 that police officers will be denied qualified immunity if they fail to comprehend that they have no right to enter a home's curtilage to make an investigation based on reasonable suspicion. That was Rogers versus Pendleton. They have no right. All they can do is engage in what's called a knock and talk. This is the scenario in the large majority of these front door type encounters with police. Knock and talks. So that's right. In this case, police officers in the Fourth Circuit were cautioned in 2001 that they would be denied qualified immunity for ignorantly believing that with just reasonable suspicion, they had a right to enter and remain in a homeowner's curtilage without the consent of that homeowner. Yet it still seems that it's being taught to police officers out there, and it's being used right now to arrest people. So, knock and talk. Under the knock and talk exception to the warrant requirement, a police officer not armed with a warrant may approach a home and knock precisely because that's no more than any private citizen might do. This means that there is an implicit license to approach the home by the front path, knock promptly, wait briefly to be received, and then, absent an invitation to linger longer, leave. An officer may also bypass the front door or another entry point usually used by visitors when circumstances reasonably indicate that the officer might find the homeowner elsewhere on the property. This is from case law. Critically, however, the right to knock and talk does not entail a right to conduct a general investigation of the home's curtilage. The obvious difference between a police officer and, say, a young girl selling Girl Scout cookies at your front door is that many, if not most, homeowners have no idea whether or not they have a right to refuse to answer the door or to ask the person to leave. And the police like it this way. They don't inform people of these rights, and the courts have ruled that they have no legal obligation to do so. So you have to inform yourself and spread the word. That Girl Scout cookie or Girl Scout uniform, police officer uniform, doesn't matter. You don't have to answer the door. You don't have to ask them. You can ask them to leave. So police officers and anyone else really, they just have an implied license to come onto your property and knock on your door. So this implied license can be revoked. Homeowners can prevent ordinary citizens and police officers alike from conducting a knock and talk at their front door. And they do that by revoking this so-called implied license to be there. However, again, few citizens know that this theory even exists. Generally, the courts require that a homeowner do engage in some clear demonstration or expression of their orders. For instance, asking somebody to leave or refusing to answer questions. Where there's a gray area, the courts will interpret. So what about no trespassing signs? So this is a topic of dispute, and this can vary by federal circuit. The 10th Circuit had a particularly bad opinion on this case in the Carlos case, which ended up resulting in one law professor creating what he called lawn signs, which were very specific and would provide notice to the police that their implied license to perform a knock and talk at that address is hereby revoked. So no trespassing signs can be ambiguous. One could certainly be more specific and avoid this gray area with some custom signs. Of course, another option is verbally telling the police that they're not welcome. Ask them to leave. That's understandably hard for a lot of people to do. And you know what? Police know this, and they use it against you. Back to the McDowell County porch case. This officer thought he was smart by saying he had reasonable suspicion, and now you have to provide identification or else get arrested for obstruction. But his own footage dooms his defense. He's clearly well inside private property. The homeowners have clearly expressed that they were afraid of him, asking for his name, which he refused. He arrested their landlord by physically seizing him on the front porch, well within the home's curtilage, without any probable cause and a warrant. The video disproves any later claim of exigent circumstances. More than that, and I haven't shown this footage yet, but he radios his superiors on the drive to jail, telling them repeatedly what he had done. There's obviously either a policy of civil rights violations in this department or systematic ignorance, or both. As always, thanks for watching. You'll find more information in the link below to my blog at thecivilrightslawyer.com. If you have a video you want me to review, please send it my way. Don't forget to subscribe for updates and hit the bell notification so you don't miss future updates or future videos. Please like, share, and comment about this video. It helps the channel. It helps the mission of exposure, education, and accountability. If you want to support the channel, please consider clicking the join button, becoming a channel member or sponsor. Remember, freedom is scary. Deal with it. See you next time.